more time. As you can hear, this event will be recorded. It is our plan to record this webinar and make it available for those who are not able to join us today for various reasons. And one of those reasons might be that we might hit the limit of participants set up by our Zoom account. We, I believe, just hit that limit. So for those of you who are joining us, thank you for making time to participate in this important webinar. My name is Oksana Bilobran, and I am a legal defense program and policy specialist with the Seattle Office of Immigrant and Refugee Affairs. This webinar is called Legal Options for Ukrainian Nationals, and it is being organized and hosted by Seattle Office of Immigrant and Refugee Affairs, American Immigration Lawyer Association, Washington State Chapter, and also Northwest Immigrants' Rights Project. All the organizers of this webinar, probably like all of you, are heartbroken by the humanitarian disaster caused by Russian invasion of Ukraine that is unfolding in front of our eyes as we speak. The goal of today's webinar is to give a basic overview of different legal immigration options that often come up in inquiries from community members. We know that all of you, legal service providers and social service providers and community members, are being contacted by people who are looking for legal immigration options for their friends and family who are in Ukraine or just escaped Ukraine. This webinar is set to discuss why some of these traditional legal immigration options might or might not work in this unfortunate situation. A few housekeeping items before I introduce our speakers. This webinar is set to run for 90 minutes with 60 minutes of presentations by our wonderful panelists and about 30 minutes of questions and answers. We have muted all participants, so please put your questions in the chat. If your question is related to a specific form of immigration benefit or relief that is being discussed by the speaker, we will monitor the chat and ask your question right after this specific presentation, but all other questions will be held and addressed at the end of the event. So we also want to apologize if we don't get to every question. We don't know how many of them we will get. Please ask your questions in the most general form possible. Our speakers cannot give out any individualized legal advice in this format of the event like this. It wouldn't be appropriate. We wouldn't know all the facts of the case. So please phrase your questions fairly general. As we already said, this webinar is being recorded and will be shared later through OIRA's Facebook page. OIRA stands again for Office of Immigrant and Refugee Affairs with the City of Seattle. If you have not liked our page yet, that's how you would find it. We have a great table of panelists and speakers today, and they include Hamdi Mohammed, the Director of Seattle Office of Immigrant and Refugee Affairs, who will give opening remarks shortly. We're also joined by Sharoninson from the law offices of Sharoninson. And Shara will be talking about temporary protective status. Maggie Cheng, a supervising attorney from Northwest Immigrants' Rights Project, will discuss an option of filing for asylum. Paula Forero, top legal management services. She's also a former national director of immigration programs at the International Rescue Committee, will give a brief overview of refugee process. Olga Prygoda is an immigration attorney at BCF Business Law, will discuss B1 and B2 non-immigrant visas, also employment and other visa opportunities. And finally, Brianna Auffray is the Immigration Rights Manager at CAIR, Washington, and she will talk about humanitarian parole. With that, we're set to begin, and Hamdi, you have the floor.
Thank you, Oksana. Good afternoon, brothers and sisters. My name is Hamdi Mohammed, and I am the Director of the Office of Immigrant and Refugee Affairs for the City of Seattle. Our mission is to improve the lives of Seattle's immigrant and refugee communities through the city's programs and services. Thank you all for joining us today for this webinar on immigration legal options for those impacted by the crisis in Ukraine. Our office is committed to taking action to protect and address the needs of our communities. Last week, Seattle Mayor Bruce Harrell announced an executive order directing City of Seattle departments to assist communities impacted by the violent invasion of Ukraine, and to ensure that we are coordinating our responses with our regional, state, and federal partners. Our goal today for this immigration legal webinar is to get accurate information out to our legal service providers, advocates, and members of the Ukrainian American community. I know there are so many people from all parts of the country that is joining us today, and Oksana has already said this, but I just want to be very clear. The information being presented in this webinar is not legal advice, nor is it a recommendation regarding a particular case. As part of getting accurate information out there, if you have a specific question about a case, you should speak with a trusted immigration attorney or a DOJ accredited representative. This is an ever-changing situation, and so our office will work hard to get you the most up-to-date information through our website, social media platforms, and we'll continue to create spaces like these types today to engage in discussions and push to get accurate information out there. Lastly, I just want to express my deep gratitude to the Ukrainian community at large, those of you who are here today, for your inspirational leadership and courage. That includes Oksana from my team. Your resistance is a testament to our democracy, and so many of us in King County and around the world stand in solidarity with our Ukrainian brothers and sisters. As someone who came to this country as a refugee, I say never lose hope, faith, or courage. We are committed to being a welcoming region for our immigrant and refugee community. I am an organizer by heart, and so I would like to leave you all with 3 items, action items today. One is to share on your social media platform information that you hear at this webinar today. Making sure that we get accurate information out to our community is so critical. 2, contact your elected leaders and let them know how important rapid action for legal and social services is for refugees. If we are a nation that welcomes and supports refugees, we should all advocate for things like raising the annual refugee administration cap. Our leaders need to continue to hear from us. And 3, donate to a local or international organization that is supporting Ukraine. On average, foreign aid assistance is less than 1% of the US federal budget. And often people think we spend so much money supporting our international community, and it's often less than 1%. So if you're able, donate to a local organization or international organization supporting Ukraine. Lastly, sign up to be on our mailing list. We'll work hard to get information out to all of you. Thank you to all of our partners and today's speaker. Thank you to the co-host of this webinar, the Washington chapter of American Immigration Lawyers Association, the Northwest Immigrants' Rights Project. We cannot do this work without all of you. And so now I will turn it back over to Oksana, our legal defense program and policy specialist, who will be facilitating this discussion. Thank you.
Thank you, Hamdi. Without further ado, I will pass the microphone to Lenson from Lenson Legal Offices to discuss a legal option of filing for temporary protective status, or TPS. Shara, are you there? Okay, my apologies. I might have to stop sharing to check what happened.
There we are. Sorry, I was trying to unmute myself. That took a minute. Okay. My name is Shara Svensson. I'm a private attorney, immigration attorney. I have an office in Snohomish County, and our office focuses pretty much entirely on family-based and humanitarian-based immigration options. So today I'm going to be talking about temporary protected status for Ukrainians specifically. There are several countries right now that do have temporary protective status, but today I'm just going to be talking about Ukrainians. So the first thing I would like to talk about is what exactly is temporary protective status, or TPS. I do want to emphasize this is a temporary status. It was created by Congress specifically for nationals of designated countries who are confronting armed conflict, environmental disaster, or other extraordinary and temporary conditions. The Secretary of the Department of Homeland Security will decide when a country merits TPS, and so based on the armed conflict and the invasion by Russia, the department decided to establish TPS for Ukraine starting March 1st. And the TPS designation for Ukraine is 18 months. So a TPS designation in general can be for 6, 12, or 18 months maximum, which means that any benefit that is received under TPS will only be through this 18-month period. TPS can be extended or terminated by the Department of Homeland Security. They have to announce their intention to terminate 60 days prior to the expiration. Otherwise, it's automatically extended for 6 months. Who is eligible for TPS? As a Ukrainian, you have to be a national of Ukraine. You have to have been in the US on March 1st, 2022, and continuously present and residing in the US since that time. So people who were here before March 1st, 2022 would be eligible to apply. You cannot have 2 or more misdemeanors or any felony conviction. And also, you cannot have firmly resettled in a third country before entering the United States. It's estimated that about 30,000 Ukrainians would be eligible for TPS. Temporary protected status provides lawful status in the US for the time that it's in effect. And with TPS, it also covers the period of time while you're waiting for your initial application to be approved. It does provide work authorization, a stay of removal if somebody has an order of removal prior to TPS. You can request advance parole, which will authorize you to travel outside the United States. People with TPS do not have to have a reason for advance parole for permission to travel outside the US, but you do have to apply separately. And again, to be aware, because TPS is only for 18 months, any work authorization that you receive, any advance parole permission to travel that you receive is only going to be valid through the end date of the TPS program. So in this case, March 1st, 18 months after March 1st is going to be September 1st of 2023. So you will, if it may take several months for the work authorization to be approved. And again, it may take, 4 months, 6 months for travel permission to be approved. And it will only be approved through the September 1st, 2023 designation period. Assuming that TPS is renewed or extended, you will have an automatic extension of your work authorization at that point. What TPS does not do is, again, it is temporary. There are several countries whose designation has been terminated over the years. With the last administration, we saw an attempt terminate TPS for various countries, and through litigation, they were able to maintain their TPS designation, and the current administration chose not to move forward with terminating the designation of TPS. But again, it's temporary. It is not a permanent solution. TPS does not automatically provide a step towards permanent residence or citizenship. It does provide lawful status in the US, lawful presence in the US, authorization to travel, and those may be a way to obtain residence in the future, but TPS by itself does not provide a step towards permanent residence. Once the TPS designation ends, anybody who is holding TPS will revert to whatever status they had before TPS. So for somebody who was undocumented in the US before applying for TPS, they would revert back to that status. The TPS designation is for Ukrainians who are in the US on March 1st, 2022. So it will not be available to anyone who enters the US after March 1st, 2022. TPS also does not include any derivatives or family members. So every applicant must meet the requirements on their own. How to apply. The government has not yet provided they haven't yet updated the USCIS website. My understanding is that they do need to wait for the TPS designation to be published in the Federal Registry before they can start accepting applications. However, this is the website where you can find information about TPS generally from USCIS, and also once the government updates its website, this is where you will find the forms and the filing instructions and the filing address for Ukrainian TPS. The basic forms, the I-821 is the application for TPS. In addition, if you would like a work authorization together with the temporary protected status, you would file form I-765. Very rarely, a TPS applicant also needs to file a waiver for certain forms of inadmissibility. And then you would use form I-601 for that. If that's the situation, I would strongly recommend that you speak with an attorney or a BIA representative about that before filing for any waivers. The supporting documents that you need to apply, you'll need proof of your identity, proof of your nationality. You need to prove when, to the best of your ability, when you entered the US, especially if it's near the March 1st date. If you've been in the US for years, they're less concerned about establishing a specific date. And you need to show continuous residence in the US from March 1st to your date of application. The filing fees are $50 for the I-821 and $85 for the biometrics. In addition, $410 for the work authorization form, for a total of $545. You would also need to include passport style photos. I didn't list that on what to include. Things to be aware of with TPS, dual nationality. A person who is a national or a citizen of two countries or more than one country, Ukraine and something else, may still be eligible for TPS, but you do need to show that that Ukraine is the primary nationality, and you need to watch out for issues of firm resettlement in a third country. And so some of the things that the government will be looking at is what passport did you use to enter the United States. If you've requested asylum, what country are you claiming asylum from? Where did you last live before entering the United States? A person who is considered to have firmly resettled in a third country prior to entry to the US is not eligible for temporary protected status from Ukraine. So for firm resettlement for TPS, the Immigration Office is looking at, did you enter into another country and also receive an offer of permanent status in that country? The exceptions may be exceptions to the firm resettlement bar to TPS is if that you have no significant ties to a third country, for example, fled the home country, only remained as long as necessary in the third country, and did not establish any ties to that country. Or also another exception to firm resettlement is if the third country imposed restrictive conditions on your residence or status in that country, such that you could not really live freely in the third country. Another issue to be aware of is that people with certain other non-immigrant statuses, such as F or certain H visas, need to make sure that they are not violating the requirements, the work requirements related to those statuses by obtaining a TPS work authorization. So if you are here on another non-immigrant status, it may be better to only apply for TPS and not the associated work authorization. Generally you need to file within the specified period of time. That you may be able to file outside of that time, but you need to show the reason that you filed after the required time period. So one reason for late filing is often that a person is already in status, and so they have not filed for TPS because of that reason. So in that case, the late initial filing may be waived, but generally you can hold TPS and other non-immigrant status at the same time. So if you believe that you're eligible, it is generally a good idea to go ahead and file for TPS in the case that you need it in the future.
Thank you, Shara. Megan and Christina, do we have any TPS specific questions from the chat? Okay, if we don't have any TPS specific questions, we can move on. Thank you, Shara. I think the message that you're trying to convey is that this is a good option for people who were in United States on March 1st, not for those who might be coming later. Is that the summary?
Unfortunately, it is not an option for anyone who has entered after March 1st. I did see a couple questions about work authorization. Yes, you can apply for work authorization at the same time you apply for TPS. And there was a question specific about living in a third country using your Ukrainian passport. The question that immigration will look at is, were you firmly resettled in that third country? Did you have some kind of permanent residence or some other permanent status in the third country before coming to the US? For the waiver, there's very few cases where you need to file a waiver. So generally, basic immigration violations such as overstaying your visa, entering without authorization, those are automatically waived as part of the TPS application. And then, so most of the waivers I think would be related to health issues possibly. And though there are specific rules applicable to TPS applicants for a waiver. So I would ask any specific waiver questions of an attorney who is looking at your specific case.
Yes, thank you. Yes, as I said, the goal of this webinar is just to give a very basic overview. So if you do have any case-specific questions, as we've all been saying, please do seek legal advice from a DOJ accredited rep or an immigration attorney. Thank you, Shara, and we're ready to pass the mic to Maggie Cheng, Supervising Attorney at the Seattle office of Northwest Immigrants' Rights Project. And Maggie is going to discuss an option of filing for, or non-option of filing for asylum. Maggie, can you unmute yourself?
Oksana, this is Christina. I'm sorry, Megan and I were unable to unmute ourselves before. There were a couple TPS specific questions. We can either go to them now or come back to them later.
I think we, in the interest of time, because it's already 12:30, we should move on and leave the questions for the end. Let me see.
I'm ready.
Okay, good. The speakers who had to unmute themselves now, was it difficult? Are there any additional barriers? Do you want us to be unmuting you?
You need to give us permission to unmute, so just heads up.
Okay, thank you.
Thanks. So can I have next slide, please? So today I'll be giving an overview of asylum eligibility and benefits, the asylum process, and a brief update on the current situation and what's happening along the border. Next slide. So in order to apply for asylum in the US, you must first be physically present in the US. Usually that means that, for example, you have entered into the US on a visa such as a tourist visa or a student visa. It's important to note that there's no such thing as an asylum visa that allows you to come into the US to apply for asylum. So typically what we see is that people already had a visa prior to fleeing. And I'll let my co-presenters talk more about maybe some options to get to the US. But unfortunately, that means that if the persons are not already in the US and don't have a way to get to the US, asylum is a non-starter. To qualify for asylum, they have to show that they have suffered past persecution or that they will face future persecution if returned. And by persecution, I'm referring to really serious harm. And they have to show that the harm was on account of a protected ground, that they were specifically targeted because of their race, religion, nationality, political opinion, or membership in a particular social group. So because of this nexus or motivational requirement, general civil strife usually is insufficient to qualify for asylum. So we have this kind of perverse paradigm where the more generalized the harm, the harder it may be for an individual to win asylum. You also have to show that your home country government is unable or unwilling to protect you, and that you can't avoid harm by simply internally relocating elsewhere within your country. Next slide. So there are several things that may bar you from being able to get asylum, and the first is a technicality. So generally, applicants have to submit their asylum applications within 1 year of their last entry into the US, with some very limited exceptions. And you also, again, same with the TPS, you may be ineligible for asylum if you have been firmly resettled in a third country prior to coming to the US. And again, it's the same analysis as to like what ties you have, what status you had, whether there are any restrictive conditions in the country. So if you had some sort of refugee or permanent resident status in EU or Mexico or some other transit countries prior to coming to the US, you may be ineligible. And again, all that is very fact specific. For example, my understanding is that the EU member states are offering temporary status to the Ukrainians fleeing. So that might be something to watch out for. The US also has a safe third country agreement with Canada, such that if you are traveling through Canada to basically try to get to the US, you will not be allowed into the US and you will have to apply for asylum in Canada first. And quite honestly, you're probably better off in the asylum system in Canada. And if you have certain criminal history, or if you have national security grounds, for example, supported terrorist organization or anything like that, that will also bar you from receiving asylum. And finally, you have to show that you merit asylum as a matter of discretion. Next slide. So if you, after jumping through all that hoop and check all the boxes, if you are approved asylum, what you get is indefinite asylee status, which grants you the right to work and live in the US. You'll also gain access to federal public benefits, and you'll be able to petition for your spouse and children, and be able to travel internationally if you obtain a refugee travel document. Sorry, please go back. But note that the asylees should not return to the country of persecution, or their asylum status may be terminated. 1 year after the asylum grant, you may be able to, you'll be eligible to apply for permanent residency, otherwise known as a green card, which then puts you on a pathway to citizenship. Next slide. So there are a couple postures to the asylum process, and which pathway you go down on mainly depends on how you enter the US. So for today, I'll be focusing only on the pathway B, affirmative asylum, and C, arriving asylum seekers, because those will probably be the most common scenarios for the Ukrainians coming. So affirmative asylum refers to those who enter on a valid visa, such as a tourist visa, student visa, or even those who enter without inspection and were just luckily were not arrested or had any interaction with immigration enforcement. These individuals will be able to apply for asylum and be interviewed by a USCIS asylum officer. And the asylum officer would decide whether to grant asylum, or if for whatever reason they do not grant, they will almost always initiate deportation proceedings or immigration court proceedings and refer the case to immigration court, so that the applicant would then have to argue the case in front of an immigration judge all over again as to why they should get asylum. And the judge will decide whether to grant asylum, or if the judge denies the asylum, they'll enter an order of deportation. So there's always a risk that if you apply for asylum and it does not go well, you may end up in deportation. The C pathway for arriving asylum seekers refers to those who are coming to the US and request asylum at the border, or even at an airport if they have a valid visa, but were just too honest and said, actually, I'm not really here for tourism. I'm here to seek asylum because I'm afraid to go back to my country. The US basically responds to the cry of help by immediately detaining them. And typically inside the Immigration Detention Center, they'll be given what's known as a credible fear interview, which is a preliminary assessment of whether the person have a plausible claim to asylum. And if they pass this pre-interview, then they'll have the opportunity to go in front of a judge and apply for asylum and argue their case. But if they don't even pass that interview, there's a chance that they may be denied and returned right then and there without even much opportunity to apply for asylum in front of a judge. Next slide, please. So the overall asylum process could take years, depending on whether you're in immigration court, whether you're on expedited docket, whether you're detained. Even for those who are on that affirmative asylum process with the asylum office, it still could take years. And that's in part because during the pandemic, the asylum office has not scheduled any asylum interviews here in Seattle, locally Washington, since March 2020. And they've only recently resumed interviews in January 2022. But by now, there's something like 12,000 cases pending, and they're primarily focused on the Afghan cases right now. So it's going to take a while to get through the backlog. Regardless of whether you're in immigration court or in front of the asylum office, there is no right to appointed counsel in immigration matters. So the applicant is somehow expected to navigate through this complicated immigration system on their own, unless they have the resources to hire a private attorney or are able to get legal assistance from a nonprofit legal aid organization like NWIRP or others. And for those who are in immigration court proceedings, they may be detained in immigration detention. And while their asylum application case is pending, and again, that could be years, they do not have access to federal public benefits. Depending on what state they live in, they may get some state benefits. So for example, here in Washington, they can get basic food stamps. But generally, there are very limited support for asylum seekers. So the asylum seekers may not have access to employment because it would take a really long time to get a work permit. They don't have access to housing benefits or Medicaid benefits, so really much medical or social assistance other than charity. So this is one area that community members and advocacy groups can really get involved in to help with social assistance and providing services to asylum seekers so that they could survive while their case is pending. Next slide, please. As far as what's going on right now, as probably most of you have seen in the news, most of the Ukrainian refugees are all headed to Poland and other European countries. And again, honestly, they may be better off there. But there are some Ukrainians who are trying to seek asylum in the US who do not have a valid visa to come to the US, and they're trying to gain entry along the southern border via Mexico. Because it's relatively easy for the Ukrainians to get, to travel to Mexico, although they'll still be subject to Mexican immigration inspection. But more importantly, they'll be stonewalled by a policy known as Title 42, which was a Trump administration era policy that's still in effect today. And Title 42 have effectively shut down all ports of entries for all nationalities along the southern border. So there have been reports of Ukrainians trying to present themselves along the U.S.-Mexican border to get into the U.S. to seek asylum and being turned away and therefore prevented from seeking asylum in the U.S. So they may be stuck in Mexico, unable to enter. And the conditions for migrants are very dangerous, especially because the cartels and traffickers target migrants, especially those who look very out of place. And the migrants may be turned over to Mexican immigration and again subject to Mexican immigration enforcement and deported, or even be forced to apply for asylum in Mexico, in which case it may trigger the firm resettlement issue so that they may be ineligible from receiving asylum in the US if they apply in the future. Because of all these problems, we at NWIRP and other immigration rights organizations are advocating for the end of Title 42 because it is a horrible policy that restricts the rights of asylum seekers and prevent them from accessing protection. And I ask all of you to join us in asking the administration to end Title 42. Next slide, please. For those who manage to enter through the southern border, there are some limited exceptions. On a case-by-case basis, you usually have to apply beforehand. And also Title 42 no longer applies to unaccompanied minors. But there are also some people who try to enter without inspection between the ports of entries and driving through the border, and basically trying to sneak through the checkpoints to circumvent Title 42. But this act is very dangerous and technically illegal. So there's been even reports, incident a couple of months ago where CBP actually shot at a couple car full of Ukrainians and Russian refugees trying to gain access to the US to seek asylum. But as long as they touch US soil, they will technically be allowed to seek asylum in the US, though again, they may be arrested and detained. So we've already have stats of a little more than 1,000 Ukrainians being arrested by Border Patrol along the southern border from October 2021 through January 2022. And of those, the families with children are generally released and placed in immigration court proceedings, often on an expedited dedicated docket. And lest you think that expedited means, yay, faster, quicker, great. Faster also means that these applicants have less time to find attorneys and adequately prepare for the asylum case, such that most of the completed cases on the dedicated docket so far have resulted in deportation. For the single adults, they are detained, although some are lucky enough to get released on recognizance. I think here, As of last week, we know of 4 Ukrainian adults who are detained at the detention center in Tacoma. But otherwise, the immigration arrest stats are a couple months behind. So we know, and I expect that there'll probably be more coming. Although, honestly, like unless there are some changes to US immigration policy regarding like visas and parole, which I'm sure, I hope that my co-panelists will talk more about, given the lack of legal options to enter the US legally to seek asylum right now, and lack of support for asylum seekers in the US generally, and given possible alternatives in other countries, EU, Canada, you know, a rational asylum seeker may seriously want to reconsider whether the US is their top choice, at least for now. But if you are here and need assistance, in the Northwest Immigrant Rights Project, we provide legal services to low-income immigrants and refugees in Washington State through our 4 offices. So sorry, I haven't been able to check the chat box. So if there are any questions.
Thank you, Maggie. Megan and Christina, are you able to unmute yourself to ask questions from the chat?
I'm not seeing any specific asylum-related questions.
Christina, you said you either?
There are none that I see.
Okay, then with that, we will pass the mic to our next speaker, Paula Forero from Top Legal Management Services. Paula, as I mentioned, is also a former National Director of Immigration Programs at International Rescue Committee, and she will be talking about the refugee process.
Okay, thank you, Oksana. Can you guys hear me?
Yes, we can hear you.
Okay, perfect. So as Oksana said, I'll be talking about the U.S. Refugee Program. I was the former national director at the International Rescue Committee, which is a big nonprofit. Domestically, it helps resettle refugees from all over the world. So that's where I gained the understanding for the U.S. Refugee Program. Unless you work with refugees or for a resettlement agency, this is a very niche part of immigration. Because as opposed to the other immigrant categories or other parts of immigration, there aren't that many rules on it. It's something that just flowed from US foreign policy, and the law that the Refugee Act wasn't actually signed until about 40 years ago. Can we go to the next slide? So in 1980, the Congress passed the Refugee Act, which incorporated the definition of a refugee coming from the UN. It created offices called the Office of Refugee Resettlement within the Department of Health and Human Services, and it outlined which social services should be made available to refugees. Next slide, please. Very similarly to what Maggie said, the definition is practically the same. It's a group of special humanitarian concern that demonstrated a fear of persecution or were persecuted on one of the 5 grounds, right? Race, religion, nationality, political opinion, or membership in a particular social group. They're not firmly resettled in another country. They're admissible to the United States, which means there's nothing in their immigration past or in their personal, in their life before that would be against our immigration laws. But the key part is that they're located outside the US. So in this case, it would be Ukrainians who are outside Ukraine. Any country in the world, not just the neighboring European countries, but they must be located outside Ukraine. And then they would have to demonstrate their fear of persecution or be persecuted on one of the grounds. Next slide, please. So who runs the US Refugee Admissions Program? It sounds like it would be immigration. But it's not USCIS, it's actually the Department of State, the Bureau of Population, Refugees, and Migration that manages the program and works in cooperation with 9 national resettlement agencies to resettle the refugees. State Department is the main, but there are other government agencies that work in cooperation with them as well. Next slide, please. Later on, so people are asking questions about bringing relatives over. And that's based on the family-based immigration system, which is the dominant system in this country. where a family member who has a green card or is a US citizen will petition for a relative abroad. There is something analogous in the refugee program, sort of the same, but not quite. In the refugee program, there's something called priorities. Priority 1 is the general one. It's the general category that most people qualify under, which basically is someone outside of their home countries or outside of Ukraine who find themselves in another country with a fear of persecution underground. They're not firmly resettled, but they have to register with the UN High Commissioner for Refugees. Technically, a US embassy could refer you to the P1 program, or even a designated nonprofit could refer you to the P1 program. But the vast majority of them come through UNHCR. I was looking up statistics before the presentation today, and about 34,000 Ukrainians outside who've left Ukraine have actually signed up for UNHCR protection, and that's awesome. We know the numbers are about 3 million people outside of Ukraine at the moment. So if you have family members and they can get in contact with the local UNHCR, tell them to do it and to sign up for with the UNHCR. Not necessarily because they want to come here, but they do get an ID, they're put in queue, and just generally speaking, if the US refugee program is not the right program for them, there could be another country's refugee program that could be the right program for them. But definitely P1, the priority 1 system, is the one where most people will be referred through. P2 is another program, and that's for groups of special humanitarian concern. I highlighted that one because I'll talk more about it in a following slide. But that one is it's like the rules just go away for that, because that is the most flexible one. If P1 is the most popular one, P2 is the most flexible. P2 is the one where the government basically says there's a characteristic with this nationality, with this ethnic group, with this religious group, that they must be protected through this P2 program. It could be in country, it could be out of country. This is where all the exceptions are made. The list is so long that I couldn't put them for you, but in some of the links that I provide, you'll get to see them, what they are, so you have an idea of what it could be. I would say that if Ukrainians were going to have the best chance, it might be under P2, but the government has to designate P2. In previous iterations of P2, the US government has said that single women are groups of special humanitarian concern because from the country they were coming from, they were vulnerable. And in this case, this could be it, right? Because we know the men in Ukraine are staying behind. The men between 18 and 60 are staying behind to fight. And basically it's women and children and perhaps elderly who are fleeing. So that could be a way that they designate Ukraine, a group of special concern. The most recent one was for Afghans who worked for the US government last year. They were given P2. So the list is extensive there. P3 is the one that closely mirrors USCIS, the family-based immigration system, because it's spouses, unmarried children under 21, and parents of any refugee or asylee or green card holder or US citizen who came in as a refugee or who was given asylum status can do a P3. And so sometimes it means that an asylee or a refugee can go through this P3 program to if their spouses were left behind. So let's say the women come in and their husbands are back home and they're able to petition for their husbands, or maybe even their parents who couldn't come with them. They'll be able to bring in their parents. The thing is that the P3 program is a very slow moving program. The application can only be done through refugee resettlement agencies. And the government has to designate which countries. Again, it's some loopholes, it's some obstacles that they put, but it is another way. If someone is here as a refugee or asylee or a green card holder or a US citizen who was a refugee or asylee, can bring these relatives left behind. Next slide, please. So this is the only P2 program that I'm highlighting here because this is an active P2 program that people from Ukraine have benefited in the past. It's basically for religious minorities. It has to be reauthorized every fiscal year. It was just reauthorized last week. As you can tell, again, I'm putting here that processing may take 3 to 5 years. That's typical of all refugee programs, all the priorities that I was mentioning. And again, that's done through resettlement agencies. But if you think you might qualify, definitely get in contact with the local resettlement agency in your area and see if your relatives could benefit from the NWIRP program. Next slide. So for fiscal year 2022, which is the federal fiscal year, which will end on September 30th of this year, US government has said that they will allow up to 125,000 refugees, which is the highest number we've had in at least 5 or 6 years, because the previous administration gutted the refugee program in addition to the other immigration programs within USCIS. So there were very few refugees coming over. But it's already March and it's October, November, December, January. Yeah, it's been 6 months. So the fiscal year has already been ongoing for 6 months. And as of February 28th, only about 6,500 refugees had been allowed into this country. And unfortunately, what happens is that COVID and just, the breakdown of the US immigration system has negatively impacted arrivals. It's not just someone registering with UNHCR. That's only the first part of the process. They have to jump through so many hurdles just to get here as a refugee. UNHCR takes their application, refers them to a local entity that's contracted with State Department to pre-interview them and set up their file. And then when they have enough people pre-registered, then USCIS, Refugee Corps, there's Asylum Division and there's Refugee Corps. Refugee Corps goes overseas and interviews the prospective refugees, except that embassies have been practically closed. I don't even know if all refugee officers have been deployed overseas. They have to be deployed overseas. So that's gotten in the way. After someone is interviewed by a refugee officer and they pass the interview because they have a well-grounded fear of persecution under the 5 grounds, they're admissible, they will be sent on, the background checks will start. Refugees are probably the most vetted immigrant group in this country. Before they come here, the background checks take a long time. So all those hurdles get in the way, and that's why the process takes so long. I've been reading that they're trying to streamline the security process, the vetting, so that they can bring refugees from everywhere. If you notice, for Europe and Central Asia, the ceiling for this year, so the most they could bring is 10,000. They weren't expecting, that's not a high number. Most of them were supposed to come from Near East and South Asia and Africa. So this will have to get rebalanced at some point. One of the things that the government can do is rebalance it and say, in our pipeline, we don't have enough people coming in from Africa, from Asia, so we'll move those numbers to Europe. In essence, giving people from Ukraine more slots to come here. There's something also called unallocated reserve. They can move that to Europe immediately and open that up essentially again for Ukraine. They can do that as well. And the other thing is that, the fiscal year starts October 1st, and that's a whole new year, and we start from scratch again. And so the government can say, you know what, it's not going to be 125,000, it's going to be 200,000. It hasn't happened, but it's something that can happen if there's advocacy for it, right? If the government knows that there's, if people are calling and saying, we need this, we need this, we need this, it's influence, and hopefully they'll see the need for it. Next slide. This is basically how all the regions are divided based on the different priority groups, the P1, P2, and P3. So at least you can see how it's divided up. As you can see, they had no plans for P3 for this year for Europe and Central Asia. Most of them were going to come from P2, which is basically what I was mentioning, right? And only about 50 were being projected to come from individual referrals. They didn't foresee this coming, obviously, and this will get rebalanced, as I said. If the government wants to, they can do it. So it's just a question of advocacy. Next slide. And that's all I have on the topic, but I have provided you a lot of links that gives you like a history and gives you more information about refugee programs and where they stand now. Thank you.
Thank you, Paula. Megan and Christina, do we have questions about refugee?
I have a couple for Paula. Someone asked about refugee cases that went through interview and medical but were not finalized in Kyiv. Is there a protocol for handling those type of cases?
Right. So I was looking up this morning, and the International Organization of Migration runs the overseas processing entity in Ukraine, in Kyiv. They're still closed. They're going to have to transfer those cases probably outside. But then the question is, where are the individuals as well? And so it's, again, it's part, I think, part of the uncertainty right now. But as of now, IOM Ukraine is not operational.
Okay, a couple questions related to P3. Would P3 apply to spouses of U.S. citizens who are not asylees, refugees?
You have to have come through the refugee program. So the petitioner has to have been a current refugee or former refugee, or current refugee or asylee, or former refugee or asylee. It can't be someone who got a green card through the family-based or employment-based or diversity visa. No.
Okay, and similar question, or related question, is the P3 process faster than an I-130 petition from a U.S. citizen to a parent? So a U.S. citizen child to their parent, or is it hard to know?
Right. So a U.S. citizen person can petition for their parents under an I-130, right?
Yep.
Right now, the embassies are closed, so that person will have to find their way outside, either to a neighboring country to finish processing there, and whatever delays or obstacles they have to get out and do that. I have seen that the consulates are really trying to expedite this, so hopefully they could expedite it. For someone to go through the AOR process, for a parent, as I said, they must have had refugee or asylee status at some point. So if I got my green card as a refugee, as an asylee, let's say, and right now I'm a citizen, I can, bring in my mother as long as the government allows me to do it through the AOR process.
Okay, so it depends on the petitioner as well, the U.S. citizen petitioner.
Yeah, definitely. And in terms of processing times, AORs are notoriously slow. What I didn't say about the wonderful thing about refugee is that you come in with a whole bunch of benefits. It's probably the most supported immigrant group in this country because there are 9 national agencies, and probably hundreds of local affiliates who greet them at the airport, who provide them initial housing, initial food, jobs, ESOL, then further along, depending, career training, financial counseling. They get a lot of support, which other immigrant groups just don't get as much. So I would never say don't do it. I would just say, look at all your options. And as long as they're not mutually exclusive, just try whichever ones to get your relatives.
Okay, and final question for you, and I know we have to keep it quick. In terms of finding information about a Lautenberg agreement application, is there a way a family member or concerned friend could find information on an applicant's case status? And would it be possible that someone had been previously rejected could reapply now, given that circumstances may be different? This is specific to a Lautenberg related case.
Right. So if you know where you filed a Lautenberg, which resettlement agency, you should go through them. Might not be the local office that has the final information, it might be the national, but they should be able to connect you with the appropriate person, because you should have a case number, I think. And I don't think it hurt. I'm not aware that you can't reapply. So you should definitely ask them because they would know better.
Okay, and that's all I have. Thanks, Paula.
Mhm.
Christina, do you have more questions?
No.
Okay, great. So we're ready to move on, and I will pass the mic to Olga Prygoda, who is an immigration attorney at BCF Business Law, and she will talk about non-immigrant visa options such as B1, B2, tourist visa, and also employment and other visa opportunities. Olga, the floor is yours.
Hello. I'm Olga Prygoda. I'm a member of the bar in Washington State, but I'm currently based in Montreal in Canada. So I've been practicing business immigration for some time, was focused on employment-based visas, employment-based green cards, and also temporary visas. My dad is from Lviv, Ukraine. So this crisis had been, this war had been very personal to me and also to a whole large group of my clients, because among my clients are also IT companies with offices in Kiev, in Lviv, and in Kharkiv, and head offices in Seattle and in the Silicon Valley. So that's definitely been difficult 3 weeks for everyone. One of the immediate questions that were raised and from all the calls that came in, all the emails that came in those past weeks is, I'm in Poland, or I'm in Germany, or I'm in Sri Lanka, or in Indonesia, I'm Ukrainian, what do I do? Can I get a B1, B2 visitor visa to come to the United States immediately? In many situations, the simple answer is no. And again, we're not going into specific legal advice here, but generally the approval rate from what we hear on the ground had been low for B1, B2s, non-immigrant visas, visitor visas, unless there are ties to the United States, and I'll elaborate on this. So, and especially the low approval rate we've seen in Poland and other neighboring countries where the bulk of refugees are. B1, B2 visitor visa, the foundation of this category is non-immigrant intent. That means that the person applying for this type of visa must demonstrate temporary intent to remain in the United States. So the visit is finite and it's for a certain time, typically under 6 months anyway. And there is a second part to this test, which means that there are ties to the home country. In some cases, the intent to remain in the US might be temporary until there is some clarity on what's going on, and many Ukrainians do want to come back. So the first part of the test, some of people can pass, but the second part of the test could be, more difficult because many of them realistically don't even have a home to come back to. And so the ties to the home country, that part of the definition is just not there. The ties of employment or studying or having a home. So we haven't really seen any special exceptions from the consular officers on the ground and given B1s, B2s, they pretty much rely on this regulation and interpret it as is. Unless there are US citizens in the picture, or permanent residents, or close friends. So the groups who had success in applying for B1s, B2s right now are only persons who have US citizen relatives or green card holder relatives. They're saying, okay, I understand it's temporary, I just need a place to go, right? And my ultimate intent is to return to Ukraine. And I just need a place to go for X number of months, and I have sufficient funds to support myself, because B1, B2, like the questions in the chat, we're asking, you cannot work in this status. So, and you cannot apply for TPS because the cutoff date, as Shara mentioned in the beginning, it's already done. So B1, B2, first of all, is probably not an option to begin with. Again, unless if you have US ties. And second, even if you arrive to the US under this status, well, at where we stand, you cannot apply for TPS. Maybe there are some other options, but this is a bit of a situation that is not really, it's not really good status to be in. So that's for the B1s, B2s. Some people are applying outside of Europe. I had situations where people were stuck during vacation in places like Sri Lanka, Indonesia, Thailand. There seems to be a little bit more opening to allow them to come into the US and those types of visas. And again, this would be on case-by-case basis. But I would say that no one should really get their hopes up for most part for this type of application. The consulates are overwhelmed, of course. And so what the government did is they basically split the responsibility. And so when we're talking about B1s, B2s, you can essentially apply in the country where you are. And to that extent, Ukrainians are now considered as stateless persons, basically, for the purposes of applying for visas. So wherever you are in the world, you can try applying for those visas. And in Europe, the immigrant cases are being handled by Frankfurt in Germany. That's for those people who already started the sponsorship process through US citizens or through employment. That would go through Frankfurt. That's a big consulate. They're usually well staffed, but probably they will be overrun by this volume as well. And then non-immigrant visas are in other places where you are, and then the adoption cases are handled by the US Embassy in Warsaw, Poland. So that's what the situation has been. In terms of advocacy, I think what we've raised, just talking to other attorneys, to other practitioners is, it would be nice to see the US government kind of broaden this definition of B1, B2 and try to let people in at least temporarily and kind of like lower the threshold of getting the B1, B2, but I don't know how realistic that would be. In terms of petition-based employment visas, what I've seen myself is the Ukrainians are an incredible talent pool. Of course, males, most of them had stayed behind due to general mobilization law, but even women often are highly qualified. By the way, there are pools of candidates that are being formed. You can go to LinkedIn, you can go to Facebook, to Telegram, other sources, and people are applying, submitting their CVs, and they're highly qualified workers. So for persons who have an interest from a US employer and who are highly skilled, highly qualified, one of the avenues would be sponsoring them for a work permit. And this is not as scary as it sounds. It's not a magic bullet either. There are quotas for permits such as H-1Bs for skilled workers who have a bachelor's degree. So that had been a problem historically in US immigration. There are annual quotas, but there are other types of permits as well. If persons had worked for an offshore of a US company in Ukraine, they could, under some conditions, apply for an intra-company transfer visa. Some individuals could apply for O1 if they are exceptional ability in their field, and it could be in business and science, including computer science, technology. It could be in arts or in athletics. So what we're trying to do on our end is, to speak to employers. And now there is an incredible need for talent in the United States and North America in general. We try to connect them with these talent pools, with these sites that have CVs from the applicants. And if there is an interest in employing those individuals, then the work process is not that long. It's not that complicated. If the person qualifies, the time frame could be as short as 3-4 months. And again, the positive side is that if this person is now in Ireland or in Spain or in Indonesia, they can apply for the visa there and then come to the US and work authorized capacity. So that's for the employment-based visas. And so basically the last bit that I had, and I think that would apply well, at least for those options, B1s, B2s, and employment-based, I will not speak about entry of refugees or asylees, but for Ukrainians generally, COVID-19 related procedures for entry had been waived, okay? So if the persons had not received 2 authorized doses of vaccine, such as Pfizer, AstraZeneca, or Moderna, they could still come into the United States. They don't have to meet vaccination requirements of CDC. There might be some post-arrival vaccination requirements. This is a bit up in the air, but at least when they come to the US, if at least they secured some paperwork to come to the US in some form of visa, they don't have to worry about the COVID-19 requirements for entry. And that's pretty much the run through this part. So we can open up to questions.
Thank you. We have just over 15 minutes left in this event, and we still have one more speakers, but we should open it to questions for Olga. Just maybe.
Sure, and I'll just go through a couple that seem to be touching on common themes. For someone that does not have a passport, just an internal passport, who is given a certificate of identity, is that person able to apply for a B1, B2 visa?
I don't think so. I would put a big asterisk on it. I don't think it's possible for the United States. What I hear from my Canadian colleagues, because our firm practices in both countries, is that yes, for Canada, documents are being issued for entry to Canada with just a birth certificate from Ukraine. And this is fantastic. And but there is a huge difference because Canada actually allows entry on emergency travel document for Ukrainians. It's basically a one-way ticket to Canada, but upon entry, you get a TPS-like status for 2 years with work authorization. So Canada's been doing more. Back to the original question, I don't think it's possible for US B1, B2, any other type of visa right now. You need a foreign passport, Zagranic passport.
Okay, and one question that's also coming up is which posts are the best to go to in terms of B1, B2 processing? And again, acknowledging the challenges inherent to getting these B1, B2 visas. Do you have a response to that?
It would be on a case-by-case basis. It would depend on the personal circumstances. The rule of thumb is, of course, the busier the post is, the less your chances of success are. Some people are reporting wait times in Poland to schedule a B1, B2 appointment going to next year, January, February of next year.
Okay.
So there is your answer. And it's just basically where you find yourself. As I mentioned, I have situations where people found themselves in Thailand and they probably have a fair chance of success of getting a B1, B2. I'll know more next week when they actually go to the appointment and there are appointments available. Some other European countries such as France, UK, Spain, Ireland, probably gonna go on the wave and catch up with the wave, and people start arriving and they will also have scarce appointments in the coming weeks.
Okay, and then last quick question is, how can a Ukrainian applying for a B1, B2 who's not in Ukraine right now demonstrate ties to Ukraine given the circumstances of war? Do you have any ideas for that?
Well, this is the biggest question, really. I mean, I think we just have to fall on the first prong, again, without giving any specific legal advice. Each situation is different, but just have to fall on the first prong of this test and state that at least you understand that this situation is temporary and that your ultimate intent is to return to Ukraine. Showing ties where people lost their houses, their businesses, there are no universities to go to, I think it's pretty much impossible. And this is the predicament that we're facing with B1s, B2s right now. So we just count on the discretion of the US government in understanding the situation. And this is where some lobbying has to be done. And asking the consular officers to exercise this discretion and adapting the B1, B2 category to the special circumstances, and not vice versa, trying to apply very rigid regulation to extraordinary set of circumstances.
Okay. Those are the main questions, so we can move on.
I could just
Thank you.
maybe add a small anecdotal information that I've been hearing is that demonstrating tie to the home country. Some people have been successful when they husbands or male in the family that is staying behind, sort of invoking that circumstance as your tie to the home country. That, let's say my husband is in the army and I intend to join him when it's over, but that's anecdotal.
Right.
Yeah.
Well, that's a good point. I'll just interject very quickly that I think, yes, if a consular officer is compassionate, they could fall back on this. 9 FAM Foreign Affairs Manual specifically states that an offer to leave dependents behind does not constitute proof of non-immigrant intent. That was written years ago, like that was written before we were born probably, but if they want, but that's what it says. I mean, that's what the actual regulation says, that leaving dependents behind or leaving relatives behind will not, you know, serve as proof of intent. But again, there is so much up to the discretion. So maybe if it works, it works. I mean, if it works in real life, that's even better.
Thank you. And then it is 1:18 right now, and we still have one more speaker. So I will pass this on to Brianna Auffray, the Immigration Rights Manager at CAIR Washington, who will talk about humanitarian parole. Brianna.
Thank you so much, Oksana. I will try to run through this quickly so we still have some time for some more questions. Humanitarian parole is probably an immigration benefit you never heard of before August of last year because it was pretty rarely used, but it did come up as a large tool during the Afghan evacuation. And so that's one of the reasons why we might look to it during this situation. But it's important to distinguish humanitarian parole from any of the other benefits that our other speakers have already spoken about today. It is not a visa, it is not the same as asylum, and it does not convey any kind of immigration status. What humanitarian parole is essentially just a permission to legally be present in the United States and to cross the border into the United States, but without a visa, without one of these other immigration benefits that do give status. And an important thing to note about humanitarian parole is that it is inherently temporary. Usually humanitarian parole is granted on a 1-year basis. We did just see a 2-year parole granted in the case of Afghans. So that would be something that we would be asking for if we were applying for humanitarian parole for Ukrainians. But ultimately it is a benefit that is decided on a case-by-case individual person basis, and every single individual person applying for this benefit would have to qualify on their own circumstances. Slide, please. I'm not going to get into the specifics of how to apply for this today because I do think that it's a complicated enough application that I would highly recommend you consult with an attorney that is very practiced in this type of application that has this experience, and particularly maybe even within the last year, because the discretion and the guidelines that are being used to evaluate these applications have changed significantly just within the last 6 months. But generally speaking, what is required for this type of application is to show that you have a US petitioner and a US financial sponsor. Those people can be the same person, or it can be 2 different people. That US petitioner and US sponsor do need to have some status in the US, generally US citizenship or LPR status. And the financial sponsor is essentially saying that they are willing to support you if you are able to enter the country and end up in a position where you cannot support yourself to avoid you becoming a public charge. The US petitioner is really just the person that is asking the government for that permission to allow you to enter. So this does not need to be somebody related to you. It's very different from a lot of the family sponsored visas in that way. It could be someone from a community group. It could be a group of volunteers that want to sign up and be a petitioner or be a financial sponsor. That's okay. The second main requirement is that you do need to show a demonstrable individual threat. And this is one of the things that has changed a bit in the last few months, is the standard by which they're judging the imminence of this threat. You can think of this as being, it's not supposed to be similar level to what you would look for to qualify for asylum, but they are using a lot of the same touch points to evaluate a threat based on a humanitarian parole application. So you can kind of use some of those same markers to determine whether or not a threat rises to the level that they would allow an individual to be granted humanitarian parole. And finally, you do need to be able to access a US embassy or a consulate to go through processing there, to have a biometrics appointment, and to pick up a boarding foil to be allowed on a plane or other transport to enter the United States. This is where we ran into a lot of trouble with Afghans applying for these types of applications once the embassy was closed. We also have this similar situation in Ukraine now, because individuals will not be able to complete their application in Ukraine. So they will need to be able to access another US embassy or consulate, but they also must show that they haven't firmly resettled in that area, similar to what you've heard from some of our other speakers. Slide, please. So individuals that you might consider a strong candidate for HP would have all three of these qualities. So someone who has immediate relatives in the US might be a good candidate. It's helpful to show that they will have support both with housing and tangible needs, as well as financial needs. The other factor that having a family here would help is that because HP is a temporary non-status, you do need to demonstrate what your plan is to either leave after the expiration of your status, or excuse me, after the expiration of your parole, or you need to be able to demonstrate that you have a plan and an eligibility for a status that you would apply for once you're here. So showing that you have immediate relatives in the US can be helpful for saying, you know what, right now, this is too much of an emergency situation. I need to get here immediately, but once I'm there, I have this eligibility to apply for a family-sponsored immigrant visa. That can be really helpful. Again, for that second demonstrable harm requirement, it can be helpful to show that you individually have already been harmed, or someone in your immediate family, someone who is very close to you, has already been harmed in this situation. It's similar to demonstrating past persecution for an asylum application, but it goes to how well-founded your fear is that you would also be in further imminent harm. So someone who is already had some kind of bodily injury or specific threat to them or their immediate family might be a good candidate for this application. And then finally, you do have to demonstrate that you have the means to reach the US. This is not a program like refugee resettlement where there is an offer of transportation or any kind of facility to get you from wherever you are to the US. So you do need to demonstrate that you have the ability, if you are granted HP, let's say in Poland, that if they give you this boarding foil, that you have the money and the means to be able to get on a plane and come to the US. Slide, please. The catch here is a few things. So for one, USCIS right now is receiving more HP applications than they ever have. This was intended to be a very rarely used sort of loophole for extreme situations that did not fit clearly into one of the other categories that we've spoken about today. However, because of the handling of the Afghan evacuation and the fact that one of the only tools available from that crisis to help individuals seek safety was HP, there have been over 40,000 applications submitted since August of last year. And of those, USCIS reports only having adjudicated 160 so far. And anecdotally, the majority of those have been denied. So while this is intended to be something that is processed quickly and an emergency basis, it's not something that I would anticipate receiving quick results with. It will likely still be quicker than applying for an immigrant visa. It may still be quicker than going through the refugee resettlement process, but I would not count on it being something that would allow you to get family members here in 2 or 3 months. That's not a realistic expectation. Additionally, it does also cost $575 per application, which again isn't done on an individual basis. So there's no ability to have derivatives. It's not, one family per application, it's every individual. So it does become quite expensive. There is a fee waiver for this application. However, I would highly caution using a fee waiver if your petitioner is also your financial sponsor. Essentially, if you're saying that the person who's submitting this application does not have enough money to pay for the filing fee, you're also undermining your argument that that person would have enough money to be able to support the person that they're sponsoring. So it could lead to a denial of the application. Slide, please. Another issue is that, and this is unsettled, so I will give that caveat, but if an individual has already been referred into a UNHCR program, if they have taken steps to be resettled as a refugee through USRAP, then you're going to potentially run into issues with the question of whether you have alternative means. It's a little less settled than some of the other categories where if you have another status, you're automatically disclosed from applying for this status. It is still on an individual basis and there is still discretion. So right now, AILA is advising that it's not an automatic bar to being approved for this application, but you should consider it before determining which avenue is going to be best for you, because it may ultimately end up getting you denied for a parole application. Slide, please. So I know that a lot of this information today has been pretty bleak and that our ultimate recommendations are that these options aren't much of an option. So I did just want to mention that a few things that nonprofits and community groups could be advocating for that would help this situation would be to ask for a special parole program to be set up. There is precedent for this. For Cuban family reunification, Haitian family reunification, the Central American Minors Program, where the government has determined that a specific group meeting specific requirements is able to receive parole on a group basis. It makes it a much easier process, fewer hoops to jump through. And I think that this scenario would certainly be a situation that would warrant such a response. So we could ask for a special parole program, excuse me. And then like Olga said, another thing that would tremendously help is advocating for reduced B1, B2 scrutiny. Like she mentioned, generally, if you go into a B1, B2 interview and you're not able to demonstrate that you intend to return at the end of that visa, you're not allowed to have dual intent and be approved for this type of application. What we can advocate for is reduce scrutiny in these interviews, run them through the process much more quickly, and use discretion to not question people's dual intentions quite as difficult as they normally would. And then finally, something else we could advocate for is just expedited adjudications on applications. USCIS has already said that they are doing an automatic expedite on many of the applications coming from Ukrainian applicants right now. But what that means is sometimes not much. What we could actually be advocating for is more resources put to the adjudication of these applications, continue to increase hiring so that we can move through them more quickly and ultimately actually speed up the process of the applications, not just calling it expedited in name only. So that is something that we could all be working towards that would really, really improve the situation, I believe. Thank you.
Thank you, Brianna. Megan, do we have one maybe question that could summarize the questions about humanitarian parole?
Excuse me. We actually haven't had any humanitarian parole specific questions, but we are at 1:30. So did we do we have time to go over some of the general questions that didn't get answered, or do we need to close up? But to answer your question, no
Okay.
questions in the chat are about humanitarian parole that I'm seeing.
I mean, my understanding is that most of the questions in the chat are really case specific, and unfortunately, it isn't the best venue to be asking case specific questions in a webinar like that. So with that, I do want to summarize and say, if you have a question that is case specific about your family members, about friends, do reach out to immigration attorneys from American Immigration Lawyer Association, from nonprofit organizations here in Washington State, resettlement agencies. We understand that today's webinar might have not been what you were hoping for. It's certainly the information that we have isn't proving, we want to think that United States immigration system is welcoming and is set up for situations like war to quickly, exponentially move people to safety. But unfortunately, as you have heard today, it's not really the case. And therefore, the advocacy needs to happen. We encourage you, especially those who are not dealing with a lot of emotional burden of caring for loved ones or family in Ukraine. If you work for nonprofit organization or legal service providers, please step in and do that advocacy on behalf of Ukrainian community. And help with some of the points that were vocalized here today, specifically about a special parole program, reduced B1, B2 scrutiny, and expedited adjudications. So that's a big ask to all of you. This webinar will be posted on our office's Facebook page. Again, our office is Office of Immigrant and Refugee Affairs, City of Seattle. Find us if you know somebody who wasn't able to access this webinar today due to our capacity limit. We also will be posting more information on our social media. And with that, I want to thank all of our speakers and everybody who attended for your participation. And Slava Ukraini. Have a good day, everybody. Bye.